May I continue, please?
Yes.
Just to mention that after my learned.
Yes. Certainly. So Mr. Sibbil after this, and then Mr. Datta. Fair enough. Yes.
150. Yes. My lords, just two cases I wanted your lordships to note, my lords. I have submitted a volume 3 small compilation. Your lordship need not open it, your lordship just note, my lords, if your lordships doesn't mind, my lords. That is about how spouse is understood in section 5.1.
There's something called annexure 3 here.
Compilation 3. Volume 3.
Volume 1, Volume
Yes.
2, amended written submission.
Yes,
Annexure 2.
compilation.
Annexure 2?
Compilation volume 3.
Yes, compilation volume 3.
At page
वहीं पर है, उसके नीचे है.
Volume 3, yes.
What is the page?
PDF 161.
205 pages. 205 pages.
161. Lalita Gupta.
Is that 2011?
Yes.
2012?
That's right.
This is Kajju, I think.
This is
You said PDF 161, which is actually a judgment called
Lalita Gupta.
Leela Gupta.
Leela
Gupta was Lakshmi Narayan.
Leela Gupta, my lords, paragraph 13.
Para 13.
My
Yes.
Lord Justice Bhatt has it.
I'm just trying to
160.
pause it to
If the Lord will come,
161?
PDF.
my Lord Justice Kohli Lord has it.
161.
Yeah.
Mila?
Just above para 14.
Yes.
6 lines. The word spouse has been understood to connote a husband or a wife, which term itself postulates a subsisting marriage. The word spouse in subsection 1 of 5 cannot be interpreted to mean a former spouse, because even after divorce, when a second marriage is contracted, if the former spouse is living, that would not prohibit the parties from contracting them. So only emphasizing this word spouse, Lords. Although that is apparent, Lord, this is one judgment which my learned colleague could find out. Lord.
All right. What else?
Now, Lords, on the issue of originalism also, this is not in the compilation, Lords. In 2017 12 SCC page 1, Jindal Stainless,
Yes.
para 184 and 202.
Would you repeat it, please?
2017,
Yes.
volume 12 SCC, page 1, Jindal Stainless, para 184 and 202.
On original interpretation.
On my lord, the entitlement of the court, my lord, to look into, or rather necessity to look into the Constitutional Assembly debates. There are large number of judgments, but this is for 9 judges, so my lord, I just picked this out.
Not necessary to read it.
Not
please.
necessary.
Yes.
Because n number of judgments are there, not where your lordships have looked into this. Of course, Lord, I don't mean to say, Lord, that things are frozen. That's not the contention. The contention is what I wanted is, Lord, that what are those circumstances, what are those limits, Lord, on ignoring, Lord, so there has to be something really fundamental, Lord, which has an impact.
Point is taken, yes.
That's
all right. What is the next point now?
Then coming back to the written note, Lords.
Final written submission.
Yes, final written submission.
Finally.
At page 9, there were 3 cases, my lord, which Mr. Vishwanathan cited. Well, also will find these 3 cases are dealt with, my lords, the DS Nakara, my lords, and Vishnu Das. They were both on, my lords, administrative orders.
Cut off date.
So it had nothing to do with a legislative enactment or a constitutional provision. So reading in, reading up and down, all those principles were not involved. Cut-off date was struck down in Nakara's case. And Vishnu Das, there was it's a transport matter, was a scheme. Found discriminating was struck down. And in association of old settlers also, it was a case of striking down some portion so that old settlers could also be accommodated. In none of these cases, brother, anything was read into any enactment. That too of a substantial nature, as is sought here. On Ghedan, my lords, much has been said. By the learned Solicitor General, all of which I adopt, my lords. If your lordship turns to page 14, kindly just note, lord, that in Ghedan, my lord, I have extracted here the Secretary of Council for the Secretary of State